from the 23rd District. I'm joined by my colleague and good friend, Senator Kwame Raoul. We're here to announce the introduction of House Bill 4323, which is the first piece of modernized legislation in the country regarding daily fantasy sports. So whenever you watch a football game or a baseball game these days, you are inundated with ads for daily fantasy, and these games where you can go online or on your phone and try to lock in a lineup and play against your friends or play against a group of people and try to, frankly, win a contest. So with the advent of any new technology, it's incumbent upon policymakers to be at the forefront of that and to make sure our statutes reflect the best practices of a given industry. So with the introduction of House Bill 4323, we feel we've gone a long way toward bringing state statute into the 21st century when it comes to this popular technology. The bill does the following things. It defines what is considered daily fantasy sports in Illinois, including ensuring that it is not gambling under the state's criminal laws, and it does not involve the betting of point spreads on any games. It prevents players from overplaying. It allows daily fantasy sites to check players for child support or tax liens. It promotes standards for auditing, and it bans anyone under the age of 18 from playing the game. There's a reason we see FanDuel and DraftKings advertising so frequently during Sunday football and other major sporting events, and why policymakers in Illinois and around the country are paying close attention to this new technology. We need a debate over how to best provide popular entertainment and protect players in Illinois. My hope is this is a good framework to have that conversation get started. We hope to put this before my colleagues, Senator Raoul's colleagues in the Senate, for a good, robust debate in the spring of 2016 and build a statute that Illinois can be proud of. It's important to reiterate, Illinois could be a leader in Illinois or in the country in developing these standards and be something. This could be a point of pride in how we allow people to enjoy this technology while at the same time protecting players. So with that, I don't know if Senator Raoul has anything to add. He's been a tireless champion for consumer protection issues in his time in the Senate. We've worked on numerous pieces of legislation together, and I'm really excited that he's the Senate sponsor of the bill.
I'm not going to add much. I will just say, by way of perspective, I think the provision that sets an age limit is particularly important to me. You know, by admission, when I was a high schooler, I self-diagnosed myself as a compulsive gambler because I used to play blackjack, and I lost, I think, $150, which was a lot of money back if you dial back to when I was in high school. And as a result, you know, I think it's important for us to keep up with both technology and with things that could be characterized as gambling. What we do here by way of the age limit, by way of having protection from overuse, by way of subjecting these entities to auditing, is we're trying to keep up. And this is, as Representative Zalewski pointed out, this is a beginning point. I think it's we're the first in the nation to attempt to address this. And again, from my perspective, as someone who kind of got myself in a little bit of trouble when I was 16, 17 years old, I think it's a good beginning point.
Happy to take your questions.
Does it appear that these sites approximate too closely gambling? Is that why you need to put it on there?
Well, I think the question is open enough that we, as policymakers, have to make the judgment of what they really are. I think they will tell you that they were games of skill, that it takes a tremendous amount of skill to go online, pick a lineup that you think is going to perform better than X amount of people in the country, and outperform to the point where you win that contest. There's a good case to be made for that. I've played fantasy sports, and I know that you cannot willy nilly pick a lineup and expect to win. So, to the extent that we can draw a good hard line of what this new and popular technology is, I think we'll do it. I think we'll make sure that players get to play it. They want to play it. We don't want to take it away from them. We want to encourage it. But at the same time, we need some common sense provisions in the law. Dane, just from my knowledge of gaming in the last 18 months, we've seen those revenues go down independently of whether there's a daily fantasy statute on the books. Um, Quite frankly, everyone's got a smartphone. Everyone plays these games. The model is such that you want individuals on their phones playing these games. It's hard to get them out of their living rooms and into a casino. So I think that it's a recognition of a new and popular technology that people really want to play. I, d- I don't. The focus of the legislation is not to tax fantasy sports. I think, first of all, it's such a new technology that you'll we don't really know how to do it. And second of all, I think, frankly, it's a loser politically to tell people we're going to tax your fantasy sports. Everybody likes it; it's popular. So my goal is to get the law on the books, make it a fair law, make it a comprehensive law, and make sure that we protect players while making sure that people get to enjoy the games. Well, Senator Raoul might agree with me that she's going to evaluate existing state statute. So we have the chance to write the state statute and clear up any confusion about whether it's gaming or not. I think that's the better way to go. No, because I think that again um, you know what sports betting is. It's had a long history of being out in Las Vegas. There's defined parameters about who can do it and who can't. We don't. Everyone will tell you the gaming board asked for an opinion from the attorney general. We the statute's vague, at least in my own personal opinion. So on a legal basis, I don't think you can make the direct comparison between sports betting and gambling or in daily fantasy sports. And quite frankly, when it comes to that aspect, we have to think about what's happening now. And what's happening now is these players are playing, they're depositing money into these escrow accounts. So let's make our statutes reflective of the reality. Let's not do what we did 30 years ago when it came to sports betting. Let's be forward in our thinking and try to put our arms around this. Again, we want to be consumer friendly. If daily fantasy operators want to operate in Illinois, we think it's good corporate citizenship that before they're going to pay these big jackpots, they do the necessary legwork to make sure that people who owe the state of Illinois money, people that owe dependent mothers money, get their money before someone gets a daily fantasy jackpot. We contacted them. They were aware that it was getting filed, and my understanding is they pledged to work cooperatively with us on this. So, in any instance of gambling in Illinois, my understanding is statute has protections to where if you're a abusive gambler or someone that should not be on a riverboat casino or at a horse track, there's ways to throw flags up and say, hey, you shouldn't be here. You've diagnosed yourself as a problem gambler. Don't do this. We would expect daily fantasy operators to do those same checks within their own protocols. So we would say, if you're going to operate these sites, we want to make sure you're doing everything you can subject to audit and regulation in Illinois to protect problem gamblers from doing more than they should be doing on these apps.
I think, well, you know, you getting into some semantics. The point is that, and I'm speaking again as a person who is a young a boy, felt that self-diagnosed. There was one time I subsequently gambled. It was a day after I took the bar exam, and what I did as self-protection, I took exactly the same amount that I lost as a high schooler, $150. I took no credit cards. I took nothing as a self-protection. This is the same type of philosophy we try to embrace with this legislation, by allowing the participant to have that self-protection and mandating that the sites have a mechanism to do so.
If the will of the colleagues is that of our colleagues is that something that should be evaluated, Dane will certainly take a look at that. This is a discussion piece designed to begin a conversation. We want to try to move something in the spring. We want to take our time with this. We want to get it right. So we're going to have various conversations with stakeholders and try to build a good, strong bill as we go forward.
It's important to note that right now there's nothing, right? And so we can get overly ambitious and leave with nothing, or we can try to wrap our arms around this, and that's what we're trying to do, is just trying to wrap around. There's no state that has anything dealing with this, in any of the states, and so you know, we're not trying to get to the point where we're overly ambitious, trying to define it as the same as a casino or anything else, but we're trying to do something.
Um, so the bill has is a specific statement that this is not gambling subject to criminal sanction. Um, Dane asked the question earlier, well, what's the difference between sports betting and this? My argument is, frankly, this is so new and uncharted waters that we can make that apples to oranges comparison, but frankly, we have the opportunity to deal with this specific issue and craft a good piece of legislation on this issue. Um, and second of all, I just think that, quite frankly, if the argument is this is skill based and it takes a lot of effort to go into picking these lineups out, then we should focus on the fact that it's skill based and try to build the best possible statute off of that. I, I, the Attorney General is a fierce champion for consumer rights, so I'll defer to her judgment on what she plans to do with respect to the gaming board's question. I know for a fact that if we build a strong enough statute that protects consumer rights, I think the Attorney General will be for it.
Is it sending a mixed message to have something in there saying it's not gambling, but then you're subjecting it to similar regulations that casinos have to go through? Isn't that saying in a way it is gambling, but then carving out some gambling?
It's kind of like saying Uber isn't a taxi, but then making them be regulated like a taxi. I mean, we had the same argument 2 years ago, and I've said this for a couple of days now. They're new and emerging technologies, and they grow really, really fast, and that's a really good thing. But it only makes sense for us some basic common sense protections in the statute. That eventually, my first concern with that is that there's going to be some sort of litigation. So maybe you have a FanDuel player, DraftKings player that loses, and they don't feel that their money was properly protected in the escrow account. Or you have a plaintiff's attorney file class action and try to shut the sites down. And, I frankly don't think that's healthy for anyone. It's not healthy for the people that enjoy playing the game. It's not healthy for the companies that want to thrive in Illinois. So let's add some certainty to the statute and try to make Illinois a state leader in how we manage new and emerging technologies. We give odds
I
instead.
told you I'm not a gambling man anymore.
No predictions on that.
Can I also ask while you're both here, you're both leaders on the pension front, and that's just been completely wiped off the map of the conversation lately, and I'm wondering what you think of that. Is there any work being done right now on a new pension plan?
I think there have been some discussions from all sorts of different parties. I think Senate President Cullerton has been trying to work on another plan, which is consistent with the contract modification doctrine, because the Supreme Court has spoken and has acknowledged that we've got to acknowledge the contractual relationship. And so the from his perspective, and I share his perspective, the only way to do something different is by way of contract modification doctrine. There's got to be a this for that, and for all parties to agree to change. And so it's difficult. I mean, the courts have spoken, and the initial plan that President Cullerton had, they took the carrot away before in the Conerva decision, before we even confronted whether we had to observe the contract modification.
I would just add, echoing what Senator Rose said, we're very limited in what we can do there. We're basically limited to finding an outside source of revenue and building out the Edgar ramp so that this isn't a crushing weight on our budget every year. So those are frankly the only two options we have, and if we can build in consideration, entice more employees into to dealing with that compound interest, we should. But we have very limited options in the toolbox. It's a matter of trying to get something on the board and trying to get it passed, and try that and see if that passes scrutiny.
In the interim, we should make our monthly payment.
Thanks, everybody. Thank you for coming.